Good morning, everyone. Great. Good morning, everyone. Can anyone hear me?
Yes, we can hear you.
Okay, thank you.
Good morning. I don't know why I'm not sure. Can you see my face?
Can't see your face, Lenny.
So weird. I have this background from my argument at the 10th Circuit. They like distribute these for people to use. It's kind of funny. I'm just gonna log out and come back.
There you are.
I can't see you. I can see you, Mark.
I can see you, Lenny.
Great, thanks.
Everybody see and hear me?
Yes.
Yep.
Yes.
Okay, I apologize. I was having some audio issues earlier, and they're imperfect now on my end, but hopefully you all can hear me. So,
Yes.
is everybody ready to go?
I am.
Yes,
Okay, and
I am, Your Honor.
thank you. Miss Boulay, are you ready to go?
I am ready.
Great. And Miss Federico?
Yes, I am.
Great. We are on the record in the Colorado Public Utilities Commission's proceeding number 25A-0202CP. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is approximately now 11:04 a.m. on November 24th, 2025, and this remote pre-hearing conference is being webcast. This remote pre-hearing conference was scheduled in decision number R25-0778-I, dated October 29th, 2025. I will take appearances starting with the applicant.
Good morning, Lenora Plimpton for Emerald Express Transportation.
Thank you and welcome. I'll turn next to Alpine Taxi.
Good morning, Your Honor. Mark Valentine from the law firm of Keys and Fox on behalf of Alpine.
Thank you and welcome. And finally, I will turn to Ski Town Transportation.
Good morning, Your Honor. Richard Barra, B as in boy, ARA registration number 7886, appearing here on behalf of NDW Enterprises, DBA Ski Town Transportation.
Thank you very much, and welcome to you as well. So,
Thank you.
my purpose for this remote pre-hearing conference, initially when I said it, was really just to get a sense from all of you about where we are and whether there was any chance for settlement or any reason why we all will not have to drive up to Steamboat in a week. That is now morphed into addressing some motions, but then also addressing the hearing and where we are. Unless anybody wants to tell me that we should start with just where we are on the hearing, my assumption based on what I've seen in the docket is that as of now anyway, we're going forward next Tuesday. But if anybody wants to interrupt me and tell me that I'm incorrect about that, please do now.
Well, Your Honor, we do have a motion, a dispositive motion to dismiss because we did not get applicants' exhibits, and they were due 10 days after the matter went off notice, which was back in June, 5 months ago. And then there was another order from you to to file exhibits and witnesses. And again, applicant failed to file their exhibits. So we are materially, Ski Town Transportation is materially disadvantaged, or there's no way we can prepare now. We've got 3 business days. That's the latter part of today, tomorrow, and Wednesday. Thursday and Friday are holidays. Monday's a travel day. So we are materially disadvantaged, and we would request either the case be dismissed for failure to follow the Commission's rules of practice and procedure, or at the very minimum that it be continued so that we have a fair opportunity to prepare.
I understand, Mr. Barr, and I've reviewed your motion. I'm familiar with your argument. One answer, well, why don't I just ask Miss Plimpton? I'm assuming that you oppose the motion to dismiss, Miss Plimpton. Am I right about that?
We do, and I don't know if you had a chance to see our motion to strike that I sent via email last night. My team hasn't had an opportunity to file that formally within the system yet. So we do oppose, and we obviously did get it on Friday, evening, and haven't had an opportunity to respond to that substantively, and we would request that opportunity should Your Honor not decide to strike the motion for the reasons outlined.
I did see the two documents that you're preparing to file. Obviously the emails came in late yesterday. I haven't had a whole lot of time to review them. I have reviewed them. My plans, I'll just cut to the chase with respect to the motion to dismiss and the motion to strike are to accelerate the response time and welcome responses, formal written responses to them by Wednesday of this week at noon. So that's my plan. I'm not planning on deciding them today, but to welcome responses to the extent anybody wants to file formal written responses, and I'm assuming you will, Ms. Plimpton in particular, and in particular with respect to the motion to dismiss. So that's my plan with the documents been filed within the last business day. That would be the motion to dismiss. And I think the motion to strike. Do I have that right? Does that carry or cover everything that's been filed since Friday?
Well, on that topic, Your Honor, I would just, as we identified in the motion to strike, council failed to confer, and has put a number of things in there. And so had we conferred, it's possible that certain parts of the motion might not have been needed. So I guess we are happy to respond on Wednesday, but my request is that you order council to confer regarding the motion, and perhaps it can either be streamlined or withdrawn.
So,
Well, Your Honor,
well, hold on, Mr. Barra. Of course, it is a requirement to confer. There's an exception to that. I'm not sure that the exception applies to this motion, Mr. Barra. I'm not looking for anything further than just confirmation from you that the duty to confer applied to this motion. Do you agree or
it did not
disagree?
apply, Your Honor. No, it did not apply because it's one of the exceptions clearly stated. And I cited it in the preface to the motion that it is filed pursuant to not only 1405, but also 13, I forget the other number, 13, the one dealing with the various motions to dismiss. Let's see. I can find it for you. Just give me a moment here.
I'm looking as well.
Well, Rule 14 is pretty clear. It says conferral is not required for motions made in accordance with Rule 56. This is not such a motion. Motions to strike, motions for other things, and motions in 1308E. Is that what you're referring to, Mr. Barrett?
1308E, that is correct. Yes.
So this doesn't apply. It says you may file a motion dismiss or a counterclaim prior to filing an answer. That's not what this is.
So in any event, I'm standing by what I said earlier. I'm going to give you through noon on Wednesday. That will give you the opportunity to confer. And whether you confer or not may play a role in my decision on the motion to dismiss. This is a discovery dispute. Conferral sure is encouraged, at least. So in any event, the bottom line is you'll have through noon on Wednesday to respond to the motion to dismiss and to discuss any of the other, the motion to strike as well. And I would encourage you to do so. Ms. Plimpton, let me ask you this. Are you planning on offering any exhibits at the hearing next week?
Well, thank you for bringing that up, Your Honor. The thing I wanted to say about exhibits is that there have been a number So the issue of exhibits is related to our motion for discovery sanctions, which we also filed via email last night, have not yet been able to put that into the system. And so there's a lot of stuff that, that Mr. Barra, his client produced nothing, effectively nothing. There was a list of vehicles. So, we very well may have wanted some of those as exhibits. Of course, we didn't receive anything. So, I would just ask that, to the extent that we do ever receive any documents, that we be allowed the opportunity to use them as exhibits. Similarly, Mr. Valentine produced numerous documents on Friday for the first time, and obviously that is highly delayed. We're seeking additional documents from Mr. Valentine as well. And then the third thing is that there has been mention, as you may have seen in the pleadings, of this separate proceeding. Alpine is looking for declaratory judgment with respect to having been banned from the airport for some time now, I think more than 6 months now. And so we had to submit a core request because Mr. Valentine did not produce those documents as requested. We got those documents from our core request, but again, those have only quite recently been produced to us from the county. And I would also seek, and I'm happy to put this into a formal pleading, the opportunity to use exhibits if needed from that tranche of documents that we did receive. Lastly, I will note that, of course, we are permitted to use exhibits where needed as rebuttal evidence, and we very well may need to do that.
Okay, so
Your Honor.
hold on, Mr. Barra. Ms. Plimpton, tell me again, what documents are you seeking from the core request?
Well, we got them,
Okay.
but quite recently.
Okay. All right. Well, we're bouncing
Your
around
Honor,
a little
please.
bit here. Hold on, Mr. Barra.
Mr.
Mr. Barra, hold on. So Mr. Valentine, why don't you go ahead? I saw your hand up.
Thank you, Your Honor. So there's a couple of issues here. When Emerald filed its witness and exhibit list, it did not even list any exhibits. And so, certainly all of the core material could have been requested a long time ago also and submitted. And, we still have the discussion coming about the motion in limine. But, that is not new material. Emerald is putting on airport witnesses. And, the introduction of this material is going to materially change how I prepare for my case. Ms. Plimpton asked me a while ago if she'd be allowed to amend her witness and exhibit list. And I said, yes, I wouldn't have a problem with that. But I do have a problem with it if it's going to be, during a holiday or the day before hearing. A lot of time has gone by since she filed her witness and exhibit list. And so we are in a bit of a due process conundrum here as far as preparing for hearing. If she wants to introduce new evidence, I'd ask that you, in the alternative, continue this hearing so that we can prepare.
Okay.
I just feel like it's important, Your Honor, to note that Mr. Valentine conditioned his position on amending, on allowing him to serve a full new set of discovery outside of the limits that exist. So it wasn't a simple go ahead.
No, that's right. And I certainly don't mind Ms. Plimpton as amending her exhibit list as long as we get a chance to review the material and conduct discovery and then go to hearing. I got no problem with that.
But just to be clear, Your Honor, we are prepared to move forward. our evidence is in the form of witnesses. We have witnesses from the airport. We have witnesses from city council. We have quite a few witnesses. All of them were listed timely manner on our disclosures, and they're all ready to come. So I would say we have the ability to produce rebuttal. That is in the rules, that if we need to produce a document for rebuttal, we are permitted to do so. That's my understanding, and I defer to your honor, but we aren't necessarily seeking any special dispensation for exhibits. We're prepared to go forward.
So it sounds like, Ms. Plimpton, you're prepared to go forward without your exhibits and relying perhaps on attempting to get them in rebuttal to the extent that's appropriate.
If needed, but we're relying on our witness. We have witness testimony, and I believe that's the strongest evidence possible. So should they need to look at a document to refresh their recollection, perhaps, but we don't need to submit it as an exhibit. The rules of evidence are loosely applied, right, in this proceeding. And then I would also note that your honor is permitted to take judicial notice, administrative notice of certain things, and that's in the regulations. So perhaps we would need that, but as of now, we're ready. They have exhibits on their list. We may need rebuttal exhibits, I don't know. And we have our witnesses ready to go.
Okay, Mr. Barra, you wanted to say something. Why don't you go ahead?
All right, thank you. Yes, you asked Ms. Plimpton a simple question. What does she have as exhibits? Well, we finally got the answer that she doesn't have exhibits. But my problem with that is that there are no financial exhibits in the application. There's none in the witness list or exhibit list. My client would like to see where the money's coming from. I mean, I have been practicing before the PUC for 45 years, and during that time, I've seen almost everything, including a visit from the U.S. Treasury Department asking to look at all my PUC clients' records because they were concerned that transportation was a vehicle for washing illegal funds from drug deals and other things. Now, with that in mind, I think it behooves us to at least see if applicant has any money, and if so, where it's coming from. And those are in the form of exhibits. We can't do it through witness testimony.
Okay, Mr. Barra, is that issue? I mean, what you're basically pointing to is no documentary evidence of financial fitness. It sounds like, at least in part.
That is correct. That is correct.
And is that the subject? I'm losing track of all the motions that have been filed within the last business day. So is that the subject, at least in part, of your motion that you filed late on Friday?
That is correct. I mean, that is my motion, please. That is correct. We are looking for the exhibits of applicant. It is customary. It is the rules that applicant files exhibits. I have never, in 45 years of practice, I have never seen a case go forward where the applicant says, well, we'll talk our exhibits through our witnesses. We have to have concrete documents to review in advance, and we haven't had that, and that's prejudicial. We've been denied our due process right to prepare.
Okay, so like I said, as to that motion, anybody who wants to file a response is going to have through noon on Wednesday. So let me just ask, this is somewhat the elephant in the room. Mr. Valentine has already raised it. So what impact does the declaratory judgment petition proceeding have on this proceeding, if at all? My understanding is, Mr. Valentine, I believe you filed it. It's been accepted by the commission. It addresses the question of whether the Yampa Valley is a regional airport, I'm assuming, has the authority to ban your client, Mr. Valentine, from providing its transportation services at the airport. And so it's been accepted. It's in the notice period. The notice period will end December 4th. I believe, and then that proceeding will go forward. So, Mr. Valentine, I'll start with you. What is your position about whether that has any impact on this proceeding?
I think, Your Honor, it has potentially significant impact. As I put in my motion in limine, Yampa Valley Regional Airport does not have the authority to regulate common carriers. And, the commission typically regulates common carriers. A Cpcn is a property right that can't be implicated without due process. And there's been no due process with regard to the contract dispute between the airport and Go Alpine. The airport has decided on its own, etc. You're nodding your head. You know what I'm about to say.
Well, I'm familiar with all of this. And
Right, right.
my
And so
question is more narrow. It's essentially, I'll cut to the chase. Is there an argument to continue this hearing, maybe even stay the proceeding until the outcome in the declaratory judgment action is known?
I think there is, Your Honor, and it flows through to the motion in limine. If the airport can't ban Alpine, then the predicate for this application goes away. If you review the witness and exhibit list, this case is about the airport's preferences to have a second carrier or a third carrier even. And that decision goes away. So that's the argument for continuing or staying this hearing.
Well, the applicant could still prove that there's a public need for their proposed transportation service, and that the existing service is substantially inadequate, even if your client is allowed to and is providing the service pursuant to its CPCN. Isn't that right?
I think that that's true, Your Honor. There is no question, but the witnesses, as I read the witness and exhibit list, aren't here to testify about Alpine service. And when I asked in discovery about their experiences with Alpine service, none of them, the answer was, I don't know, because these aren't Emerald people. So if you look at the witness and exhibit list, the predicate for this case is that Alpine is going away. And Alpine's going away without any due process. We can't question the airport. In this case, we can't conduct discovery. It's a contract dispute. It's beyond the commission's jurisdiction.
All right,
There's no-
Mr. Valentine. I mean, so let's just cut to the chase here for you. Are you asking me to do anything in light of the declaratory judgment action? Are you asking for a continuance in light of the declaratory judgment action?
To be honest, Judge, I was coming to grips with that. I hadn't really decided yet what to do. And, I still think that continuing this case makes sense from a discovery perspective, but you're absolutely right that they could show substantial inadequacy. And it's not just me, it's Ski Town, setting aside the airport stuff. But if it turns out that Alpine was wrongly stripped of its CPCN by the airport, and let's be honest, the airport is everything in Steamboat, then Alpine gets its CPCN back. There will be additional due process, and Alpine will be reinstated at the airport later in the season.
Okay, and just to clarify the record, your client still has its CPCN.
It does, but it
yeah.
can't use it. Not really.
Okay, so
I mean, just to put a finer point on it, Your Honor, that's why we filed the motion in limine that we filed. If they can prove substantial inadequacy, setting aside the airport dispute, that I think you're right. That would be fine. But if that's the issue, let's focus on that and not the airport. It just, the airport dispute is a complex contractual dispute. It is a really muddy dispute. Both sides have very strongly held opinions about that dispute. And I don't think that this case is the proper way to handle that.
Okay, I understand. Ms. Plimpton, I'll give you the opportunity to respond. Mr. Barrow, I'll come to you after that. So
Thank
go
you.
ahead, Ms. Plimpton.
Thank you, Your Honor. I just wanted to address your point, which is absolutely true that Alpine was not stripped of its Cpcn. It absolutely still has its Cpcn. It's not true that it can't use it. It can use it. It can use it in accordance with its, Cpcn territory. And the airport's actions are what they are, but they actually don't directly relate to this proceeding, which is about whether there's a public need. The airport ban, whether or not it's upheld, is relevant to this proceeding because it implicates Go Alpine's ability to pay. They're in serious debt to the airport. I mean, our core request, we've seen these documents. Our witnesses will testify as to that. We have a witness from the airport. So we have plenty of evidence that there are underlying reasons why the airport banned Go Alpine from operating there. And whether or not that is in fact allowed, there are reasons, and those reasons are relevant. Failure to pay, complete lack of appropriate systems, complaints, poor service. These are all things that are relevant. So if we're talking about the motion in limine, I think that it would be, serious error to prevent us from introducing evidence relevant to this proceeding, which is the same kind of evidence that underlies the dispute between the airport and Go Alpine, but we aren't asking for a trial within a trial. There's no need for this proceeding to resolve the propriety of the airport's actions. That's a dispute between them. But there are reasons for the airport's actions, and those reasons are relevant in this action. And then secondly, it's absolutely not true. Our witness list is extremely detailed. We in no way have limited our witnesses to testifying about Go Alpine's inability, rightly or wrongly, to serve the airport. The fact of the matter is they can't serve the airport. I don't know how long that's going to last, and I don't know what the outcome will be. I believe that the airport most likely will be found to have acted properly. They have a private contract, etc. But it's not true that we have nothing outside of that. We have a lot outside of that. We have tons of evidence that will prove that the service is substantially inadequate, not just through the evidence that relates to that dispute, but also tons of other evidence. It's all listed right there in our witness list. And then finally, I don't think the case against the airport is muddy from what I understand. I think it's pretty straightforward. Poor service, debt. I mean, it comes down to that. So I'm very interested. We actually plan to submit an intervention as an interested party in that action. That period hasn't closed yet, but we're certainly interested, but it absolutely doesn't require resolution before you.
Okay, Ms. Plimpton, but so what is your position? And maybe you stated it, maybe I missed it, regarding what impact the declaratory judgment action has on this proceeding. In other words, let me be very specific. Do you think there's a basis for, or that we should continue this hearing to allow the declaratory judgment action proceeding to play out, and then hold the hearing in this proceeding after the outcome there becomes clear?
Yeah, we would strongly oppose that for the reasons that I mentioned. Right now, ski season is starting, and there is serious concern that the people that are coming to the town aren't going to have transportation. We know for a fact that Go Alpine can't operate there. So to prohibit my client from proceeding with this application would absolutely hurt the public. It would not be in the public interest. And I don't think there's any authority, or reason sort of in the law that would make it appropriate to not go forward with this proceeding, based on really a tangential. I mean, this is the way I see it. There's a public need for my client to get the Cpcn. There would be even more. I mean, it would be an extreme public need, right? If Go Alpine loses with respect to this dispute with the airport. But there's a need right now, and we want to go forward, and I think that's our right to do. So there's a public need right now. There would be even more of a public need should Go Alpine lose, which I believe they will. But we should absolutely go forward. I don't think there's any reason to pause this.
Okay. And let me ask you this, Ms. Plimpton. I think you indicated that your plan is to have your witnesses testify at our hearing about the reasons that the airport has barred Mr. Valentine's client from providing transportation service there. Do I have that right?
You're correct that would be some of the subject, but I guess it's not that my witnesses are going to start getting into the dispute about the contract, but I think that the witnesses, Ms. Gerber from the airport, for example, will say all of the reasons why Go Alpine has not been providing the service that the airport needs. I mean, I've got our witness list in front of me, but we've stated things like she's going to address the current limitations of the ground service operators. That all does relate to the airport's dispute, yes, but it also stands alone. So she's going to testify about the incredible number of problems the airport had, which, yes, is what led them to ban Go Alpine from the property, right? But it's the underlying facts here as to the airport's extreme level of dissatisfaction with Go Alpine and the really incredible need for additional service. I mean, we've got this Chamber of Commerce, City Council, airport, everyone in Steamboat is screaming for additional service. I think they needed it before, but they even more need it now that Go Alpine can't even go to the airport.
Okay. Mr. Barra, do you want to say anything here?
Yes, I do. First of all, the motion that was filed on behalf of Ski Town on Friday addressed not only the obvious of the lack of exhibits, but also addressed the declaratory order as additional grounds to either dismiss or continue the application. I don't see how this case can go forward with that, as you called it, elephant in the room, the declaratory judgment proceeding pending. I mean, it is totally going to affect the outcome of the need for service at the airport. If Go Alpine is correct, then the need for service to substitute it goes away. Now, Ms. Plimpton said that there's additional need not met by Go Alpine. Well, from all the documents that have been provided so far in this proceeding, it looks like there will be no increase in traffic this year over last year. And there were no problems last year with the service that were recorded. Now, if Ms. Plimpton is correct that she wants to provide service this year, why hasn't she filed a motion for temporary authority, an application for temporary authority? I mean, this case, even under the most beneficial of circumstances, will not finish and would not be a final decision from the commission rendered before the close of ski season. Ski season closes end of March, early April. just from past experience in these cases, we're looking at 6 months at the minimum before there'd be assuming a grant of authority, that there would be clearance to operate. There is a clear and easy solution. If there is a need, there's a temporary authority. The law provides for that. I haven't seen any applications from Emerald coming across the PUC's notices of applications filed asking for temporary authority to serve the public. So I think that is just a ruse. I don't think it's genuine. Now, what is genuine is the fact that going forward with the declaratory order, if that rules in favor of Alpine, which I think it will, because I don't see how a private entity can not a private entity, but an airport, a small airport, can foreclose a PUC sanctioned operation. They might be able to say, well, we won't give you a desk because that's our property, but they can't stop interstate commerce. They can't stop intrastate commerce. That's a violation of state and federal laws, and I'm sure that the commission will rule in go Alpine's favor. However, in the meantime, we have to be careful not to go forward with a case that is going to be going off on tangents. Now, it sounds to me like a lot of the time of hearing will not be going toward the two essential issues in a case. Is there an immediate, is there a permanent need for service not being met by existing carriers? And is the service of existing carriers materially inadequate? I haven't heard anything about that. I've been hearing more about what the airport is doing and what the justifications of why and whatnot.
So,
That's
Mr.
not
Barrett,
relevant to a.
let me just interrupt. So I understand all these arguments. So it sounds like, to the extent I do not grant your motion to dismiss, you think the hearing should be continued.
That is correct.
Okay. All right. Thank you for that.
Your Honor,
can I just
will
add?
I have a brief opportunity to respond to Mr. Barra's points?
Why don't you go ahead, and then Mr. Valentine, you'll be allowed to finish up here. This is all overlapping with Alpine's motion in limine, which I was planning on addressing here today. So this is getting a little bit unwieldy, but Ms. Plimpton, go ahead.
Well, there's a number of factual assertions made by Mr. Barra that we absolutely dispute and disagree with, such as that there were no problems last year with service. We obviously don't agree with that. Mr. Barra has discussed us applying for temporary authority. We did apply for temporary authority, and the parties, at least Mr. Valentine's client, intervened. I assume Mr. Barra's didn't, since he is unaware of that application. It was denied, so we did attempt that, and that was when, at that point, we did file for this permanent authority. I note that Mr. Valentine's client is the one who is interested in this declaratory proceeding. He hasn't filed a motion to dismiss. He hasn't filed and asked for a continuance. Mr. Barr's client is essentially uninterested. I don't think there's any direct connection between his client's interest in that proceeding, right? From his client's perspective, they need to be defending their own ability to provide service. So I don't think that they really have an interest. Am I going to go so far as to say they don't have standing? No, but it's really not their fight, right? And Mr. Valentine hasn't asked for those things. So that was the only other comment I wanted to make. But to summarize, I believe that we have the right to move forward with our case. The burden of proof is ours. The application is ours. They can make all of these arguments at the hearing as to why we don't have the right to get this authority. There's no public need, etc. But we should be able to proceed as set forth in the rules and pursuant to our application.
Okay, thank you. Mr. Valentine, go ahead.
We're relying, as you just noted, on our motion in limine to deal with this issue. And, that's really where our focus has been. And, that we do not think that Emerald should be and it's a real question for me as to whether it's Emerald or the airport should be able to bootstrap a local government decision when there's no due process into being a commission of the decision. That material it's just not prejudicial. I mean,
Understood.
this contract, I mean, of course, Alpine completely disagrees with everything that Ms. Plimpton just says. We dispute the contract. We would, if there was an action, no doubt there would be counterclaims. I mean, it's complicated. It is muddy. It's a mess.
Okay. All right. So I understand everything that's been said to me here today. Do the parties want through Wednesday at noon to respond to the motions that have been filed within the last business day?
Well, we only have this motion to dismiss to respond to, and yes, we do want an opportunity to respond substantively. The motion to strike was more procedural, but I do believe we should have an opportunity to respond. And, you know, given the holiday and the rapidly approaching hearing, that's one of the reasons why I think that this was untimely, and really very untimely. The reasons for the motion were well known for months, even as the motion states. So to have done this.
I understand, Ms. Plimpton. So it was a narrow question, and what
Yes, we
I'm
would like
really
the
asking.
opportunity.
Okay.
Yeah.
So I'm not going to rule today. I'm going to wait and give you the opportunity to respond in writing. The other two parties, do you want the opportunity in writing to respond to what? I don't even know if it's been filed yet. The pleadings that I got emailed last night. Do you want the opportunity in writing by Wednesday at noon to respond to those?
I certainly do. I don't know what we're talking about, but if and when I get
Okay.
it, I definitely want to respond to it.
Okay. Thank you, Mr.
So I would
Vara
like the opportunity. Thank you.
and Mr. Valentine.
I haven't read the pleadings yet, Your Honor. If you set the deadline for Wednesday, I'll have an opportunity to do so, and I may choose to not respond.
Okay, understood. Thank you, Mr. Valentine. So I'm going to stand by what I said at the outset a while ago, which is, I'm not going to rule on the motions, the motion to dismiss filed by Ski Town on Friday late, and I think it's a motion to strike and a motion in limine filed by, I don't even know if it's been filed yet, by Emerald Express, but that was emailed to me and I think copied all the parties last night. So anybody who wants to respond to those will have through noon on Wednesday to respond in writing. I'm not ruling on those today. What I would like to address is the motion in limine filed by Alpine Taxi. That one's been pending for a while. I don't remember. Mr. Valentine, do you remember when you filed that? You're muted.
Thank you. It was filed before the last pre-hearing conference, Your Honor, and you indicated that there would be additional discussion here today on that in that status conference. And so I think we've had that. You understand Alpine believes that that decision was made improperly and without due process and thus has no business being introduced into evidence in this case.
So, and most specifically, what I understand you're asking for, Mr. Valentine, and I'm just reading from your motion, I think it's the last page, page 7, that you're asking to, and I'm quoting here, prescribe testimony about Alpine's commercial dispute with YVRA, that's the Yampa Valley Regional Authority.
That's correct, Your Honor.
And the airport's decision to bar Alpine from providing service.
Yes.
So you're asking to basically prohibit any evidence regarding the issue that at least in part is going to be addressed now in the declaratory judgment action. Do I have that right?
That's correct, Your Honor.
Okay. And I think we had taken some oral argument on it when we last met. I believe Miss Plimpton's client had filed a response pretty close to our last pre-hearing conference, and I had declined to rule on it, in part, Mr. Valentine, because I don't think you'd really had the opportunity to review that response. So what I'd like to do is just take limited, whatever else you want to say about the motion in limine. I'm going to give Ms. Plimpton the opportunity to respond. Anything else that you'd like to add to the record? Mr. Bear, I'll give you a very hopefully brief opportunity to say whatever you want to say about it. So that's my plan. So Mr. Valentine, if you'd like to say anything further, please go ahead.
I'll just sum up again, Your Honor. It's clear that municipal governments don't have the authority to regulate common carriers. And that is exactly what the airport is doing here. Alpine's Cpcn requires it to serve the airport. The airport is named in the Cpcn, and the airport has not given Alpine any due process. It's a contract dispute. It's a commercial dispute. And Lord knows plenty of public utilities that are commission jurisdictional have disputes that occur from time to time, and it's not a basis for them to be stripped of their Cpcns. Here, there's no judgment from the commission. There's no judgment from a court. It's just the airport deciding that this isn't what we want. And there's been no due process. And Ms. Plimpton can state that we still have our Cpcn, but it's been profoundly compromised. And at this point, Alpine is at risk of an existential crisis. And so, there's been no due process. If there had been some process, there's not even been a deposition, that would be a different story. They could come in here and say, we have a court decision, the court has blessed, they haven't paid us pursuant to the court decision. But we have none of that. It's a hotly disputed case. And the law is clear. A Cpcn is a property right granted by the commission that cannot be taken away without due process. Here, it's been done by an entity that doesn't have jurisdiction over the Cpcn, and it's been done without due process. And that's why this material should be excluded. You can't bootstrap a bad decision into the commission's case. It's profoundly unfair to go Alpine. We can't issue any discovery on that testimony, and we can't get an accounting. It's very complex. We can't take depositions and so forth. So for those reasons, the motion in limine should be granted.
Okay, Mr. Valentine, we had a colloquy about this last time, but as you know, to show substantial inadequacy, the applicant can show that your client is not ready, willing, and able to provide transportation to anyone who might request it. And here, as I understand it, your client is not able to provide transportation service to the airport for the reasons you've stated. So why isn't that relevant to the decision that I have to make? And frankly, it is relevant. I'll just tell you, it's certainly relevant to the decision I have to make. So I need to know that. I also understand it may or may not be temporary, the inability. I don't know the answer to that. That's going to be addressed in the declaratory judgment action. So you're not asking me, I don't think, not to even consider this. And I'll tell you, I have to consider it. So to the extent you're asking me to do that, that's denied. But what are you asking me to put parameters around the evidence at the hearing concerning this issue?
Well, Your Honor's already ruled. I mean, we haven't even gotten into a discussion about all of the sorts of things, such as a pattern of bad service that are typically required for substantial inadequacy of service. This would be the very first case in which it's not past service, it's future service that's at issue. And, you know, the crux of this is due process. Of course, you've ruled already that you have to consider it. The question is whether or not it's fair to go Alpine to consider it. It's not. It's profoundly unfair. This is a decision that was made without any ability of Alpine to weigh in on it. And that is going to be used to grant a CPCN in this case, and that will compromise Alpine's position going forward. That's what they want.
Let me just assure you, I have not prejudged anything, Mr. Valentine, but as I think as you understand, the basis for substantial inadequacy, one key way is showing that an incumbent is not ready, willing, and able. So, I mean, this evidence is relevant to your client's current ability to provide the transportation service. And you're right, in the typical case, an applicant shows that the incumbent is not ready, willing, and able by focusing on historical service. And we're, maybe we'll be focusing on that as well, but I can't just disregard the fact that your client is currently unable to provide service to the airport. The question of whether that's correct or not, that's not for me to decide. That's going to be addressed in the declaratory judgment action and not here. So, I mean, I'll ask it again. I'm not sure that you answered it. I mean, are there parameters that I can place that you're asking me to place around the evidence at the hearing, such that, Ms. Plimpton's witnesses cannot testify as to topic X?
Well, so Your Honor, what I would ask then is if you want to let in the fact that Alpine has been barred by the airport, I understand why that's relevant to you in this case. I have big problems with that because I think it's got a very weak foundation. But let's not get into all the accounting and the contract dispute. I mean, that seems to be well beyond the commission's jurisdiction anyway. And let's keep it, I mean, we've stipulated, right? I will tell you that drivers from Alpine have gone to the airport and they can't get in, So, if you want to take judicial notice of that fact, we can streamline this hearing very significantly.
Okay. And I understand that, Mr. Valentine, it has some sense to it. And I'll just tell all of you that I really do not want to have a hearing that's addressing evidence that's going to duplicate what's going to be presented in the declaratory judgment action. So anyway, let me turn to Ms. Plimpton and get a response to what you just heard. I mean, I do see, Ms. Plimpton, that you have the airport director on your witness list.
That's correct.
Let me just read through what the disclosure is regarding that witness.
And you might want to also look at Mr. Booth is another witness related to the issues with the airport. I believe some others of our witnesses may discuss this, right? The Chamber of Commerce, et cetera, but yes, please.
Ms. Plimpton, I see, well, first of all, with regard to Mr. Booth, he's the former airport director. So he held the position that Ms. Gerber currently holds. Is that right?
That's right.
And so in the third paragraph of Mr. Booth's disclosure in your witness list, it states Mr. Booth will also testify regarding the April 2025 loss of Steamboat Express's airport contract. And then it goes on from there. Who's Steamboat Express?
That is an alternative name for Mr. Valentine's client.
Okay.
Right, Mark, please feel free to.
Yeah, it's DBA as I understand it.
Okay. So it is your client, Mr. Valentine?
Yes.
Okay. All right, so I've read that. So let me just ask you, Ms. Plimpton, let me tell you what I'm inclined to do, and then I will welcome what other additional record you want to make. And this is going to be a fine line that's going to have to be worked out at the hearing, I think. But what I'm thinking is that what I will allow at the hearing, obviously, Mr. Valentine is stipulated, because he has to, that his client can't provide service to the airport currently. What I really do not want to hear, and I don't think I need to hear in this case, is detailed evidence regarding the reasons why. Now, the caveat to that is I'm inclined to allow your witnesses to talk about the quality of Mr. Valentine's service, client service, prior to being barred from providing the transportation service. But, you know, I don't think I need to hear about the nuts and bolts of the details, particularly if there's any personality issues involved in this. I mean, the fact of the matter is, I need to know, and I will know, Mr. Valentine's client cannot currently provide service to the airport, and I need to know about the quality of Mr. Valentine's client's historical service, and whether his client was or was not ready, willing, and able to provide the service prior to the decision to bar Mr. Valentine's client from providing transportation service. So a couple of questions. Number one, does that make sense? And number two, just generally, what's your response to that, Ms. Plimpton?
Yes, I appreciate that. Well, my first comment is a larger one, and I think we made this in our response, which is that Your Honor this is not a jury trial. You're going to be proceeding and controlling this hearing, and I don't know, this is up to you, but I don't know why you would want to limit your own, ability to control the proceeding and as you see fit, right? So of course, if our witnesses get too far afield, you could stop that. I'm not actually clear on what exactly Mr. Valentine does not want us to say. So that's my first thing. And second, I think you've already covered the things that you say you want to hear about are what we want to tell you about. So I don't know what exactly, I don't know of any personality issues. We don't want to get into drama. I mean, we want to present evidence that goes to the software issues that they were having, the quality of service, the complaints, all of these reasons that the airport is unhappy. We don't want to talk about due process. I mean, that's really not relevant to my client. So your first question, does this make sense? It does make sense to me. I guess before we end, I would love to have just like maybe a bit more information so that we can prepare to not go into matters that you don't want to hear about, but certainly personality issues, whatever those might be, we don't need to talk about those things. What you've outlined is exactly what we want to present. We want the airport director to be able to speak freely about these were the software problems. I do think that the payment issues, I don't think we should limit her ability, but if it gets far afield, you can obviously prevent her, and we would respect that. But I think perhaps if the testimony was they had a massive number of unpaid invoices. I mean, that's relevant. Your Honor is capable of giving it the weight it deserves. But I think financial issues at a higher level, without going into the weeds, do relate to ready, willing, and able. Are you able if you can't manage your financial operation? Are you able if you don't have software systems that work, et cetera? So without belaboring it further, I'm actually fine with the way that you have outlined what you need, and that aligns with what we want to provide.
Okay, thank you, Ms. Plimpton. Mr. Valentine, I saw you, maybe it's inaccurate to say gesticulating, but
Well,
I
I
sense that you
just
want to
want
say something.
an opportunity, Your Honor. I would like to reserve the right to review the witness and exhibit list and to object to testimony based on what's set forth there. I understand what you're saying about the scope of testimony, but I don't read the witness and exhibit list the same way that Ms. Plimpton does. And so I just want to reserve my rights on that front. And to the extent that Ms. Plimpton goes into unpaid invoices, we're going to want to go into why.
Right. Okay, so I understand you're reserving your right to object. And that makes sense. You really don't need to reserve your right because I'm not barring you from not objecting. I hear what you're saying.
It felt like we were going down the road of blessing testimony.
I'm trying to give broad guidelines. So obviously what I want to avoid is a trial within a trial here of an issue that I have very significant questions in my own mind about how relevant the reasons are for the current state that we're in, meaning Mr. Valentine, your client, not being allowed to provide its transportation service to the airports. I do need to hear about the history of the adequacy of the service that was provided to the airports, so I can make my judgment about whether that service was substantially inadequate or not. So anyway, those are broad guidelines. Frankly, I think we only have 3 days for this hearing. Is that what it's scheduled for, Tuesday through Thursday?
Yes.
And based on what I'm hearing, this could be problematic for even getting this in 3 days. So anyway, you have my parameters at this point. I'm granting in part and denying in part the motion in limine filed by Mr. Valentine, consistent with what I just said. And, we're just going to have to deal with the lines that I recognize are not entirely clear at this point about what's going to be permissible or not permissible. That's kind of the downside of motions in limine, is that a lot of times it's really hard to make decisions pre-hearing about exactly what's going to be permissible and not permissible. It's largely context dependent in many motions in limine. It really is in this case. So, Mr. Barra, I promised you I'd give you the opportunity to weigh in. If you could be brief, I'd appreciate it.
Well, there's a lot to comment on. It seems like there is a conundrum because, as you point out, you must look at the situation as it is. And if Go Alpine is not providing the service, then that's going into the issue of whether it's willing and able to do so. But is that fair? Is that due process? Is that fundamental fairness? When we have a commission proceeding where the commission has recognized that this is a problem that they will be taking up. So what happens if the way I see it right now, if you have to take into consideration that Go Alpine is not providing the service, well, then it's a given that anybody who has asked to provide additional service is going to get authority, and that's not fair. Because the day after you render your recommended decision, the commission could come out with a decision that says, Go Alpine was wrongfully excluded from the airport, and then all of a sudden we have an overabundance of carriers. Now, everybody's been talking about ski season. Nobody talks about the 9 months of the year where my client barely survives because its operating ratio, its conscious is maybe 20% of capacity because there's nobody who rides those buses in the summertime. Everybody drives the steamboat in the summertime. So in order to survive and provide year-round service, which it's duty-bound to do under its authority, it needs to be able to get as much traffic as it can in the wintertime. If another carrier is granted primarily because of a fluke, and that fluke is Go Alpine is prohibited from providing service to the airport at this point in time. Admit it. But does that mean that there's a permanent future need for service of Emerald? No, it does not. It's just today. And we have no way of knowing until what the commission does in the declaratory judgment situation as to whether or not there would be a continuing problem for Go Alpine's ability to serve the airport. So I think the only due process, fundamentally fair way to do this is to continue this hearing until the commission acts on its declaratory judgment proceeding.
Okay, thank you, Mr. Barra. Let me just ask you very briefly. You've heard my ruling on Mr. Valentine's motion in limine. Do you have any comment about the fuzzy lines that I've attempted to put in place?
I don't. I think you've done the best you can under a very difficult situation. But if I were the judge in this case, I would exclude everything. I would exclude everything about the airport because it's not relevant to the issues before the commission. It's a separate proceeding, and both you have pointed that out, and Mr. Valentine's pointed that out. It's just going to take up maybe 2 days of that 3-day hearing. And what we need to do is we need to focus on the issues before the commission.
I understand, Mr. Barron. We'll just have to respectfully, hopefully, on your part anyway, disagree about the relevance of access to the airport to this application. So that's where we stand. I've granted in part and denied in part Mr. Valentine's motion in limine. As to the remainder of the motions that I'm aware of, since late on Friday, you all will have the opportunity through noon at Wednesday to file responses. So we're done with that portion of this pre-hearing conference. Let me just turn to the hearing itself. Let me just ask each of you how many witnesses you think you're going to have. Ms. Plimpton, I'll ask you. You know as well as I do that you had 9 witnesses listed on your witness list. Do you currently anticipate that all 9 are going to testify?
Wow, that's a great question. I don't think probably all 9, but I kind of wasn't exactly prepared to. So we've got my client Bradley 1, Ms. Gerber 2, Mr. Booth 3, 4, Brady Cox. I mean, I suppose if I'm put on the spot, we would probably use all 9, but you know, as a practical matter, probably not all 9. So I don't want to like limit our ability to bring 9 if needed, but some of those would not be very lengthy. I mean, maybe it's safe to say 7, but I know for sure that we're going to have 4 or 5.
Okay.
Yeah.
All right, that's helpful. And I'm not trying to limit you. I'm just trying to get a sense. And a lot of times in these proceedings, you know, you file the witness list fairly far in advance of the hearing, and you find out subsequently either your case has changed or you have witnesses who said, sorry, I just can't do it for whatever reason. So it doesn't sound like either of those apply. You're reserving the right to bring all 9, but you think that it's certainly possible that only 4 or 5 will testify. Is that a fair characterization?
That is, and actually, if it would be helpful, I can talk to my client after this hearing and perhaps provide some kind of a, update to the parties and to you, Your Honor, if that would be helpful.
It may very well be. We can decide that at the end. Let me just ask Mr. Valentine and Mr. Barra. I'm not looking at your witness list currently. My recollection is I think each of you had 1 witness listed.
2, Your Honor.
You have 2, Mr. Valentine. Do you anticipate both will testify?
Yes.
Okay. And Mr. Barra, how about you?
I had 2 listed, and I believe 2 will testify.
Okay. All right. So let me ask this question. This is obviously an in-person hearing in Steamboat. I can't remember who exactly requested it be in person in Steamboat. Can this be done remotely? I don't think any of us is cherishing the opportunity to drive up to Steamboat during snow season. I'll just tell you, I'm not. So if it can be done remotely, that would be great. If it can't, and you know, you may interpret this as me putting pressure on. I'm not. If you need it to be in person, I'm committed to that. We're going to do that. But if things have changed since the request for in-person in Steamboat, now's the time to let me know. So I will start with Ms. Plimpton.
Thank you, Your Honor. I certainly, as a resident of the Front Range myself, do relate to your desire not to drive up there. However, it is very important to my client that this be in person. All the I feel like it's safe to say all of the witnesses are up there. Certainly my client is, his staff. We believe that it will just be a better hearing if it is in person. So it is quite important to us that be in person. With respect to, I do apologize that we're going to have to drive up there, but it is important to us.
Okay, thank you for that. Mr. Valentine, I'll go to you next.
We're ready to be in Steamboat, Your Honor.
Okay, thank you. And Mr. Barra, I think you were pretty adamant originally that it be in person in Steamboat and adamant isn't fair, but you wanted it in Steamboat. I'm assuming that's still the case.
Your Honor, no, we're amenable because we understand the realities of life in the mountains. And so if Your Honor were to change this to either an in-person hearing in Denver, which would be wonderful, or a hybrid hearing, that would be okay with us. In any event, we're not any longer enforcing our request to have it in person in Steamboat. We would go whatever what Your Honor thinks is most beneficial and safe under the circumstances.
Okay, thank you for that. So, what I'm going to do, we'll keep it as in person in Steamboat. And just pay attention to email. I have not looked at a long-term forecast. But if we're going to get a whole lot of snow, and it will be very difficult for all four of us in any event to get up to Steamboat, that may play a role. Like I said, I haven't looked. I don't know what the forecast is, but I'm just giving you a heads up. Just pay attention to your email just in case something develops that's beyond our control. And we'll just deal with it if that happens. So, I think that's all that I plan to cover today. Is there anything else that anybody would like me to address at this time? And or have I missed anything that's pending? And I'll start with you, Ms. Plimpton.
Yes, thank you. I did want to mention, given time constraints, we have had one of our witnesses become unavailable, and we want to, I guess, orally move to be able to swap. I haven't had a chance to talk to Mr. Valentine, Mr. Barr about this, but we want to swap someone in that's going to testify to the exact same stuff. And that's Mr. Muntian, Steve Muntian. He is no longer available, so I would ask for leave to be able to update our witness list to just swap in a witness for that witness.
Okay, and like you say, Ms. Plimpton, that new witness would be limited to the disclosure regarding Mr. Muntean in the witness list?
Yes, it would just be a
Okay.
new person on the
Okay.
same topic.
Do you know the identity of that person?
Yeah, I don't have it directly in front of me, but I'm sure Brad, my client, would love to chime in right now. But it would certainly would be on the it will be on our amended. I don't have the. I could
Okay.
quickly.
All right. Well, let me just turn to Mr. Valentine, Mr. Barra, and see. Notwithstanding that we don't know the identity of this person yet.
Okay, I have it. Sorry, it is
Okay.
Michael Buccino.
And how do you?
Can you spell that, please?
Yeah, it's Buccino. He will replace Steve Muntian if the dates. Yeah, Steve will be out of the country.
Okay, Mr. Valentine, I'll turn to you first.
I guess I'm curious as to who he is, and I mean, I expect that sort of as long as he's stuck with what's on that witness and exhibit list, I'd be fine with it.
Okay, but are you reserving judgment at this point, reserving the right to object?
Sure.
You're welcome.
Thank you.
So, Mr. Barra, how about you? Same thing or something different?
We would reserve the right to object. I have to consult with my client over that, but I have a feeling we'll probably object because I know the name, I've dealt with the person, and I think we may object. But like I said, I'd like to consult with my client first.
Okay, thank you to all three of you. Ms. Plimpton, I'm going to reserve judgment on that as well. This is going to be another game time decision. So that I can hear more in detail from Mr. Valentine and Mr. Barra.
Well, so what do you mean? Should we not update our witness list should I file a motion, or because I just, really there will be no prejudice. It's literally just a different person saying, on the same topic. So, Your Honor, do you want us, how should we proceed with that? Because I don't want to give a maybe to this person or, schedule them, et cetera.
So I think you're going to have to give this witness a maybe. You're raising this now at the 11th hour. Mr. Valentine, Mr. Barra have not heard it before now. You know, I think I'm obligated.
We did just hear ourselves. It is important.
I'm not casting judgment on you. I'm just telling you what the reality is here. And I need to give Mr. Valentine, Mr. Barra the opportunity to object after having thought about it for more than a minute at most. So if you want to do this, you take whatever action you think is necessary in order to make it happen. You know, then I'll make my decision. So
Would Your Honor like us to file a motion on that so that it can be teed up for them to respond? I wouldn't really want to take up more time of our 3 days to, you know, get into this issue, and it is quite important. And then I would make an alternative request just for your consideration. There's been discussion of exhibits, and we have a letter of support from the city that relates to Mr. Muntean's testimony. He's a city counselor, and so this would be another city councilor. So to the extent that there is, you know, an inclination to bar a replacement, we would ask that we be permitted to produce that letter of support as an exhibit.
well, I mean, I'll tell you, so I take it Mr. Pacino is not a city council member?
He is a city council member. It's
Okay.
just really as pure of a replacement as you can get. Because it's an aligned city council member that we would not even change the description, right, of the testimony. Because these two gentlemen have the same view, and they both signed off presumably on this letter of support from the city. So again, I don't think there's prejudice here at all. It's just another person doing the same thing.
If this is another city councilor, Your Honor, I'm not going to object.
Okay. And Mr. Barra, I don't hear you changing your position. Am I right
That
about
is
that?
correct. I still have to confer with my client, but I am inclined to oppose, especially now that we now have an additional thing where we have to amend a letter and there's not, and somebody else's name is going to be on the letter. I'm inclined to oppose this.
Okay. So, you know, I'm going to go ahead and allow you to do this, Ms. Plimpton. Mr. Barra, you can, you know, at the hearing, make an oral motion for reconsideration as you deem fit. But for planning purposes, I'm going to grant this request from Ms. Plimpton. So with that, Ms. Plimpton, is there anything else you'd like me to address?
No, Your Honor, nothing comes to mind. I appreciate your time today.
Thank you. Mr. Valentine, anything further?
Nothing further, Your Honor. Thank you.
Thank you, Mr. Valentine. Mr. Barra, anything further?
None, Your Honor. Thank you.
Okay, thank you all for being here today. Like I said, just pay attention to your email over the weekend and on Monday. If there's going to be a big weather event, it may very well be that I will at least initiate a conversation with the four of you or the three of you about whether it makes sense to go up to Steamboat next Monday. So with that, let me thank you again, and we are adjourned for today.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Whew.